have been at the Attorney General's office since 1981 with minimal detours, and I actually shared an office with Kevin McConnell at one point. When we got there, well, I think I was there a little bit before you, there were really, eviction plans were the major game in town. In 1981, our office lobbied to amend the statute. It's 352 quadruple E of the general business law, for those of you who are taking notes. And there was a lot of back and forth between the tenant lobby and the landlord lobby, because really, basically, there was no co-op and condo industry then. Condos were unheard of. We have a statute that was based on the Puerto Rican statute. That was really, San Juan was the only place there were condos, and it hasn't been changed. So our condo statute really could use to be updated. But the tenant protection statute was amended to provide for non-eviction plans. There was a lot of negotiation, and finally, the way the statute ended up was that you could convert a tenanted building to a non-eviction plan, which gave all tenants the right to remain, continued occupancy without unconscionable rent increases. Now, we interpret unconscionable to mean if you're regulated, you get your regular rent stab or rent control increases. If you're not regulated, you can't go beyond market. That's where this seems to have ended up. The other piece of it was, at the time, you really, if you recall, and I'm giving you a little history lesson here because I want you to know what our office has done for the past 30 years and how we've ended up with the jurisdiction we have, which is somewhat limited for many people's purposes. The statute says you can declare a non-eviction plan effective if you sell to 15% of tenants or people who intend to, who purchase with the intent to occupy when the unit becomes vacant. It used to be, the landscape in the 80s certainly, and into the 90s, was that it was tenants that were doing the negotiating, it was tenants that were doing the buying. The statute was written in anticipation of sales to tenants being made. These outsiders who represented that they would move in once it became vacant. These apartments never became vacant. So it wasn't, people were regulated. So it was really important to negotiate with the tenants and sell to the tenants. The reserve fund law, which is sets up a fund of money for capital improvements to buildings that are old and occupied, have been occupied for a while, these tenanted buildings, that was based on the price that the tenants were paying. Everything was really about the tenants. You couldn't have any discriminatory inducements to tenants. You couldn't divide and conquer. You couldn't offer half the tenants one thing and half the tenants another thing. They wouldn't count towards effectiveness if you were giving special deals to tenants. And then, after luxury decontrol, everything really changed. The landscape was totally different. We'd get these buildings would come in that they had half emptied. Well, the Sheffield was an example on 57th Street. You know, I was sitting in the room with the developer once, and he was complaining that these people, you know, the tenants that were there didn't understand that the building was being converted. And I said to him, I think it's that you're just pretending they don't exist. He was building a building around the tenants, basically. So we've had to throw ourselves into situations like this that we really, very, very different than how it used to be. We were always hamstrung because our office originally tried to prevent buildings from converting that had asbestos or dangerous and hazardous violations posted on them, and we went all the way up to the Court of Appeals and we lost. So really, we're working with a disclosure statute in many ways, except for the warehousing provision. If you, did you hold up the one already? I'm sorry, I lost track. Okay. As long as you're not warehousing and you're disclosing everything, every shred of asbestos, everything, every violation, we have to accept the offering plan for filing. And if you sell enough apartments, you can declare it effective and convert. So now what we have really is a whole different set of problems. We're trying to set up construction protocol for these half-empty buildings where these construction is really going on around the tenants. This is our most common issue. And then, of course, we also have, we do have powers to some extent in terms of preventing harassment to tenants that remain, non-purchasing tenants, preventing unconscionable rent increases, and preventing, and the statute specifically gives us the right to look into the discriminatory delivery of services. If you are servicing the building, you have to service the non-purchasing tenants as well as the purchasers. And you go into these buildings now and you see, you know, there's a marble floor on one side of the hall where the purchaser is, and there's, you know, shabby linoleum on the other one, or there's some penciled apartment number 1, and then this grand, beautiful brass number on the other. So this is the sort of this is just a brief history of what our office is dealing with. And I didn't even get to the fact that all the shoddy new construction that's going up, which, you know, I think New York used to be known as a well-built city, and it's really, in the last construction boom, we've had so many construction problems. It's almost like, you know, being, you know, in Florida. Anyway, so we're trying to deal with those too.